A very good afternoon, ladies and gentlemen. Thank you for tuning in. Hope you are all having a pleasant day. It's great to be back again this week with another episode of the Strata Talk Show. With that, I would like to welcome everyone to the 48th episode of the Strata Talk Show, brought to you by the Excel Academy of Real Estate. In this talk show, we'll be discussing issues and cases related to the management of stratified developments with various industry professionals. Joining us today, we have Mr. Leong Chee Weng, who is a partner of Tuang, Chu Co, to speak on the topic of build bridges, not walls, understanding your rights and obligations as landlord and tenant. If you have any questions for Mr. Chi, feel free to leave them in the Facebook comment section below, which will be addressed in the Q&A section at the end of the show. Without further ado, join me in welcoming Mr. Chi. Welcome, sir.
Hello, hi, Nafa. Thank you for the kind introduction. First of all, I'd like to wish our Muslim friends a happy fasting. I hope it's not too late. And thank you once again, Excel Academy, for having me on the show. And this time to share on a specific topic on relationship between tenant and landlord. I'm sure most of you may be a tenant or landlord at some point, whether commercial lot or residential lot, and some of you may have your fair share of issues during your tenancy. So the topic today is titled Build Bridges, Not Walls, Understanding Your Rights and Obligations as Landlord and Tenant. The idea is, while you may face certain issue during your tenancy, I think it's important for us to understand what are your rights and obligations, both as a tenant and both as a landlord. And as both parties are more aware on your respective rights and obligation and what to look out for in your tenancy relationship, perhaps you can sort of try to prevent any unnecessary issues, and hence the title Build Bridges, to have constant communication between tenant and landlord so that you avoid having to resort to litigation or going to court. In fact, recently I've just concluded a trial on a tenancy dispute. It is your usual dispute, where the tenant is suing for the return of security deposit and the landlord is suing for rental for unexpired term and the cost to restore the unit. Of course, in my case, the tenant is one of the famous tire provider, whom the name I shall not disclose. But the issue there is very common, and I'm sure maybe some of you may have experienced it as well. The issue that arose there is, can I terminate the tenancy earlier? Or do I have to pay the rental for the unexpired term? And what is the landlord's right when it comes to security and utility deposit? And what happens if your tenant move out and they fail to restore the premise to its original condition? So these are some of the areas which we will aim to cover today. And without further ado, I think we will move on what are the topics that we're going to cover today. So the first part, I think we're going to highlight what are the important clauses or important area that you should have in your tenancy agreement. Now, you may have signed, tenancy agreement. You have signed many, or even maybe some of you have not signed any tenancy agreement. Your tenancy agreement, you have various forms. Some may be simple, some may be more complicated. But one important thing that you need to take note of is the importance of this agreement. Because why I'm saying this is important, because whatever rights and obligations that you as a landlord and you as a tenant have is usually spelled out in your agreement. Of course, in some instances, even though some rights are not in your agreement, the Malaysian National Land Code actually has certain provision that imply certain rights and obligation to you as landlord or tenant. But the point I'm trying to make is whatever rights or whatever risks that you foresee in your tenancy, my advice is strongly to put everything in your agreement. And this is why it's important to have a very comprehensive tenancy agreement. Because otherwise, in the event of any dispute, your tenancy agreement is going to make or break your case. A poorly drafted tenancy agreement will really, really affect your right, both as a tenant and as landlord. So in the first part of this talk, I'm going to sort of share with you what are the important areas that your tenancy agreement should have or should govern. And then we have part two, which is I'm going to set up some of the common obligations as a landlord and tenant, And the last part is the more interesting, where we explore some of the case studies. I also share with you some of the case law in Malaysia and also in UK as well. And we discussed some scenario. For example, under what circumstance can a landlord claim for double rental? Or for example, if a tenant does not pay any rental and they continue to stay in the unit, what can you as a landlord do? Can you cut the electricity supply? Can you change the law? I think these are very common, and there's a lot of landlord wants to know their right. Look, if you don't pay me, can I go and kick them out? So these are some of the case study and FAQ that we're going to try to address in the third part of the talk. Now, before we start, I think I would just like to highlight the difference between a tenancy and a lease. Well, even though some people may use it interchangeably, some people will say, "Oh, I have a lease," or "I have a tenancy." But in Malaysian law, there's actually a difference between these two, because the Malaysian National Land Code actually gives a different meaning and treatment to a tenancy and lease. Of course, there's a lot of differences, but I think it can be summarized in two parts. One is in terms of the length, on how long are you renting the unit. If it's 3 years or less, under the Malaysian National Land Code, this is deemed as a tenancy. And if it's more than 3 years, up to a maximum of 99 years, if you're renting a full property, but if you're renting a part, it's between 4 to 30 years, that is termed as a lease. And why is this distinction important? Is because there is a requirement for you to register a lease. There's no requirement to register a tenancy, but there is a provision that actually allows you to endorse a tenancy. Why is this registration important? Let me explain to you. If a lease is registered, it will be endorsed in the title of your document. So whoever and anyone who does a search on the land, you get a search, you actually see the name of the tenant who has a lease over the property. And therefore, when you buy the land, you cannot kick the tenant out because you are aware of the fact that there is a tenant there. But when it comes to tenancy, is lesser, is 3 years, and usually you don't need to register. But then your danger you have is you will not know who is actually occupying or renting the place, unless of course you check with the owner. But like I said, as a tenant, in order to protect yourself, you have the option under Section 213 of the National Land Code to what we call endorse your claim on the land. It's not really so much, maybe similar to registration, but the point is to put it on record from the land office that you are actually renting the place, so that any buyer who wants to buy the place, and if you do any search, you as a tenant, your name will appear there. So that is just the distinction I would like to draw your attention to. But of course, what we will discuss today will mostly apply to both lease and tenancy. But I just want to let you know that there is a different treatment in terms of what is tenancy and what is lease in Malaysian law. Now, moving on to the next part on what are the important or area that you should cover in a tenancy agreement. This is very important because, as I mentioned earlier, in the event that there is any gap in your agreement or there's any uncertainty, this is going to lead to dispute. The last thing you want is, to go to court and to testify and to, argue what you mean by certain clauses and what happened, if there's no clauses in the agreement dealing with your specific situation. So it's important for you to have, at the very least, the basic requirement of a tenancy agreement. Now, the first area that you must address in your tenancy agreement, of course, is the detail of your property. If you're renting only a part of your property, not the full, you need to make sure you spell them out. And sometimes you may even attach a plan and you might mark the relevant part in which you're renting out. And of course, the details of the property will also include what's the address of the property, etc. And next, your tenancy agreement should also include the purpose in which you are renting the place. The purpose can be commercial and residential. And even for commercial, sometimes it can be more specific. For example, I'm renting you this lot for restaurant, or I'm renting this shop for you to run a tire shop, for example. So if that is the specific purpose you're renting it, you may want to put it in your tenancy agreement to avoid any changes and that unnecessary changes to the property. And of course, you should also spell out the tenancy period, whether 3 years or more or longer. And like I said, it's important. Why this is important is because if you're renting it for more than 3 years, you need to register under the National Land Code. So it's very important for you to specify in your tenancy agreement what is the tenancy period. Of course, some you have 3+3, 2+2. That can be in as well. And the more important one, especially for the landlord, is of course you must have the rental amount and the deposit amount. And deposit, you must also know that you have different types of deposit. You have utility deposit, you have security deposit. Both are sort of different, and how you deal with them are different as well. But at the end of the day, how you want to deal with this deposit and how you want to deal with this rental, you can spell it out in your tenancy agreement. And of course, the next one is the mode of payment. How you want it to be paid. Is it by way of bank transfer, by way of check, by way of cash, and the timing of payment as well. Usually, the typical tenancy agreement will say on the 7th day of the beginning of every month and things like that without having to make a demand. So these are basic clauses that definitely will need to be in your tenancy agreement. Of course, then you have late payment interest clause as well. In the event that the tenant failed to pay, you may want to have a clause to say you can charge interest, and you may want to stipulate what is the interest rate, etc., etc. And the next one, which is also quite important one, is the inventory of the fixtures that is in the unit. Sometimes you may be renting a bare unit, but sometimes it may not be bare. You may be renting it fully furnished, partly furnished, or whatever. So you will have certain equipments or certain fixtures, furnitures, and all this. For example, even air conditioning. So it's important for you to also address in the tenancy agreement, and if necessary, to list them out as well. Why this is important is because sometimes towards the end of your tenancy, the tenant have to return back these fixtures and furniture to the landlord. So if you don't spell it out, as a landlord, because you may be renting the place for 5 years, 10 years, and when you want to take back the unit, you as landlord, you also wouldn't remember how many fixtures were there, how many chairs were there, how many air cons were there. You're unable to verify. So why not just spell it out in your tenancy agreement that, look, you're taking this unit with X amount of table, X amount of chairs, X amount of aircon, and when you return the unit back to me, you must return to me with all these features. Of course, then you have termination of tenancy agreement, which is quite important because, as you will see later on, a lot of dispute actually revolve around termination. There's a few types of termination. Of course, you have termination by expiry. Once the tenancy has expired, has left, then you have to deal with how you're going to move out and etc. And of course, you have termination by default as well. So you want to know what are your defaults, and in the event of default, how do you exercise your right to terminate? And also, you also have termination by notice, where there's no default, but you can terminate by giving notice. Maybe 30 days, 60 days, whatever. The question is whether you have this right to terminate will depend on what is in your contract. So if you want to have those right to terminate, you have to insert this right to terminate in your agreement. And then, of course, you have your obligation post-termination. What happened after you terminate? Usually, of course, you have clauses to say you must deliver back to me the vacant possession of the unit. And as a tenant, there's also a clause we say you must restore the property back to its original state. But what I noticed in most tenancy agreement is you will have the clause to say that when you give me back the property, you must restore it back to the original state and condition. But there is no proof on what is the original state and condition, or at least it usually is not enclosed to the tenancy agreement. And the suit that I mentioned to you earlier, which I've just done 2 weeks ago, the trial I did, is precisely on this point. What the tenant actually said at that point was, well, you look at the agreement, there's no pictures on how the unit was when I took over. How do you know that I have not restored it to the original state and condition? Because you don't have comparison. You are saying that when I took over, the wall color is blue. And you say it's, but now it's pink. But what's the proof? What is the proof that it was blue color before this? I'm just giving an example. So what you may also want to consider is perhaps to at the very least have some records on what was the condition of the unit when you're renting up or when you're renting the place. And if you can, enclose those enclose the pictures of the unit into the agreement. There's no harm. This is just to avoid any dispute. And later on, when you take back the unit, you say, hey, This door last time not at this side, or this wall is actually different color, or this window used to be different. Why go through the hassle? It doesn't take a lot of effort to just snap some photos and just enclose it to the agreement. You know, of course, then the next thing you must or usually should have in your tenancy agreement is the option to renew. This is quite common. You have your 3+3, 2+2, 1+1, whatever. And if you want to have the option, you have to make sure you spell it out in your agreement. And also your agreement should also specify, how do you exercise the right to renew. Sometimes some agreement will have automatic renewal to say that upon expiry, it will automatically renew for 3 years. Some usually require notice, and you must give notice how many days before expiry that you want to extend. And sometimes you may even in your agreement agree to what is the rental for the renewed period. Of course, sometimes I've seen agreement where it says that, look, I can exercise my right to renew, but subject to the rental being agreed. But to me, that sort of defeat the purpose, because if you cannot agree to the rental, it means you cannot renew. So your right to actually renew is actually not certain, which is why what parties usually do is, instead of saying that, look, if I exercise my right to renew, you can revise your rental, but you can only revise upward to a maximum, and usually it's based on market rate. So at least in that way, you as a tenant, you are assured that you are entitled to the additional plus 2, +3, or +1. Because if your right to renew is contingent upon the parties agreeing to a rental, for whatever reason, the landlord choose to say, actually, I don't want you to renew, so I'm going to propose a very high rental rate, which you are going to reject. Then at least I can get back the unit. So if you want to prevent such situation, you want to have the certainty that I can renew at a. You may even agree to the rental for the extended rate, or at least you have a cap, so that you have certainty that you can actually extend or renew the tenancy. Then, of course, you have escalation clause as well. What is escalation clause? Essentially, it's a clause which allows landlord to revise the rental during the period of the tenancy, not during the renewal. It's optional. Of course, as landlord, you may want them in. You may say that, look, I have reserved my right to revise rental at my discretion, or upon certain thing happening and all this. But of course, as tenant, you do not want that. You want certainty. You want to know that I'm renting for 3 years. And for the 3 years, this is the rental, because for budgeting purposes or for whatever. So this clause is not very common in Malaysia. In fact, I have not seen too many of these clauses. But in Malaysia, we practice freedom of contract. If you want to have that there, no one is stopping you. You can put it in. Of course, then some tenancy agreement, you also have the issue of subletting. Essentially, it's a clause we say whether you can or cannot sublet. This is quite common in some of the perhaps students. Where a student may rent a house, but they sublet certain rooms to other students, other classmates, other coursemates, and whatever not. But in doing so, you need to make sure that there's no clause in your tenancy agreement which prohibits you from subletting. Otherwise, if you sublet without consent, it is a breach. And of course, from a landlord point of view, if you are saying that, I've interviewed this guy and I want to rent to him or her, and I don't want anyone else, renting the place who I do not know. So you may want to include this clause to make sure that, look, it is only you who is staying here and you cannot sublet it to other people. You may want to include this clause to protect you as a landlord. Of course, then the last thing that usually you have in a tenancy agreement is your obligation. What is it that you as landlord must do? What is it that your tenant must do? And which bring me to the second part of the talk, which is what are your obligations as landlord and tenant? So here I've set up some example or some common landlord's obligation. But again, I must emphasize these are just examples. These are not applicable across all tenancy, because at the end of the day, it still depends on the terms of the tenancy agreement. I'm only highlighting some of the common ones which are usually in your tenancy agreement. You can even exclude it, or you choose not to include it, but usually it will be there. So as a landlord, what is your obligation? Number one, you have to pay all necessary charges. What charges are these? Usually it's your creep rent, your assessment, maintenance fee. And sometimes if the tenancy agreement say that, look, I will also, as landlord, I will bear the utility charges. So you, as landlord, you have the obligation to make sure you pay. Because if you don't pay, then the electricity will be cut, the water will be cut. And the last thing you want is, for your tenant to come after you and say, look, because you didn't pay, my electricity got cut, and then my food in my fridge spoils or whatever happened, I'm going to claim from you for all these losses. That's the last thing you want. Of course, then as landlord, you also have the obligation to maintain insurance. What sort of insurance is quite common? Usually, you have fire insurance, and usually these are the obligation that as landlord you have to do. And of course, you have the obligation to maintain and repair certain infrastructures. Usually, there is a clause in the tenancy agreement which says, you must repair any damage, such as if there's any damage to the pipes, electrical wiring, or whatever. Of course, sometimes to be fair, you also exclude obligation to repair anything that is as a result of damage caused by the tenant. Because if the tenant is the one that spoiled it, then you may want to exclude it. But that is a bit of a area of dispute, because then the question is, how do you find out whether this is caused by tenant or this is caused by who? Because surely it's caused by something, and surely usually it's because of how the tenant has used it. Of course, if the tenant chooses to use it in a very illogical manner or unreasonable manner, you may want to have a clause to say, I'm not going to repair it. You as tenant, you're going to sort it out because you are the one who caused it. Of course, the last one, which is just common sense, you as landlord, you must make sure that you give the tenant a quiet enjoyment of the property. In other words, you cannot go and disturb the tenant. You must let them enjoy their property. It's not like every 3 days you can go and visit and just look at your house and see how it is and all this. No, the idea is you rent it out. They should have this exclusive use of it, unless provided otherwise in your agreement. Now, what about the tenant? Again, I've set up some of the examples. These are common. It's not applicable across all agreement. It's just that most agreement you have these clauses, and most of it are pretty self-explanatory. And in fact, it's something like a common sense. The first one, of course, you need to make sure you pay your deposit when you rent the place. Of course, I've seen tenancy agreement where they don't take deposit at all. So you may not even have the obligation. Like I said, it's freedom of contract. You can choose whether you want that or you do not want that. Of course, then you have the obligation to pay your rent on time. And you fail to pay, sometimes the landlord have the right to charge interest or even have the right to terminate. And of course, as tenant, you also have duty to notify your landlord of any repair. If something is spoiled, you need to inform your landlord. Otherwise, your landlord wouldn't know and cannot come and fix it. Of course, then you have duty to keep the property clean and safe as well. This is given. Since as a tenant, you are staying at a place, it's only makes sense for you to ensure that the place is clean. And you may even have certain instances where you have to pay utility bills. If the agreement is that, look, your rental don't include electricity, don't include internet, Astro or whatever, sometimes there's certain arrangement. So it is an obligation, but it's not really obligation per se, because if you don't pay, you are the only one who's going to suffer. You're not going to be able to use electricity, you cannot use Astro and all this. So it's not so much damage that is caused to the landlord, of course. But if it is spelled out, of course, ideally you should pay. Otherwise, you cannot enjoy those utilities. And of course, you have obligation to seek permission for any new tenant or to sublet the property. As mentioned just now, there may be a certain clause which prohibits you from subletting. And if there is such clause, you need to make sure that you get the consent from the landlord. Otherwise, it will be a breach, and you're going to lead to a lot of issues. And for commercial tenancy agreement, usually you may be restricted to certain purpose. Make sure as a tenant you do not violate the purpose. For example, if you're saying that I'm renting this to be a restaurant means restaurant, you cannot suddenly change to cyber cafe or send to a tire shop or whatever. And as far as residential purpose is concerned, usually you have obligation to make sure that you follow the condominium rules and regulations. For example, some condo says there's no pets, so you have to make sure you comply. No violation of car park and all this, and you need to use your common facilities properly. So these are some of the common obligations as tenant you need to make sure that you comply with. Now, while as I highlighted earlier, it seems like there's a lot of obligation for you as a tenant and as a landlord. But typically, from my experience, dispute on tenancy revolve around these few common issues, which is one, early termination by landlord and tenant, failure by tenant to pay rental, or failure by your tenant to give you vacant possession after the tenancy have ended, or when your tenant failed to restore the property. These are the common breaches. So which leads to the case study. Mostly you will see all the dispute that goes to court revolve around this four. So in these cases, the question is, what can you do? So we're going to go through some case study now to determine, what are your rights as landlord and as tenant. Now, first of all, is what happened in the event of early termination by tenant. Meaning to say that the tenancy agreement actually says it's supposed to be for 3 years, but during the first year, you as tenant, you decided not to rent anymore because you cannot afford, or for whatever reason, which is also happened in one of the cases which my firm has handled. Whereby in that case they said because of COVID, the tenant said, look, I don't want to rent it anymore. Here's the key, take it back. So in the case like this, is the question is, well, as landlord, can I insist that you rent the place, or can I claim for the unexpired term? Even though the tenant may not have stayed the full 3 years, can I claim for the full 3 years worth of rental, which can come up to a lot? The short answer is yes, as determined by this case of Berjaya Times Square against Twins Gems and Member Hut. What happened in this case was the tenant rented a space in Times Square, and it was meant to be run as a food and beverage F&B outlet. What happened there was the tenant, after only 77 days of operation, tenant chose to close the business, and they told Berjaya to say, look, I want to terminate the tenancy agreement. Of course, Berjaya didn't agree. They said, you cannot, because you've agreed to rent it for 3 years, you have to take it for 3 years. But the tenant didn't care. They just said, look, they just abandoned the unit, they removed everything, and they just returned the keys back to Berjaya. So what happened here was Berjaya then sued the tenant for the full rental for the unexpired term. Of course, the tenant was trying to say, look, there's some misrepresentation from Berjaya. You told me that area is going to be a popular area, but turns out it is not. I don't have any business and all this, so I'm not going to pay you. So what was the court finding there? The court find that, look, Berjaya is in fact entitled to the rental for the unexpired term. This is even so, even though the tenant only occupied the place for 77 days, but they have to pay the full rental for the 3 years. So the moral of the story is, if you foresee such issue, it may be worthwhile to include certain clauses which allow you to walk away. And how do you walk away? Is usually termination by notice. You may agree to a 3 years, but always have that clause there to say that at any time I can terminate by giving you 2 months notice, 1 month notice, or 2 months rental in lieu of notice. Otherwise, you may have to end up paying the full rental price, even though you did not occupy the place. So as we see, this is some of the extract of the Berjaya Times Square judgment. I'm going to leave you all to read. But the point is, the court in this case found that Berjaya is entitled to the remaining unexpired term. Now, then the next question is, if the tenant terminate early, can me as a landlord, can I forfeit your deposit, your security deposit or utility deposit and all this? What is the answer to this? The answer is, it depends. In Berjaya Times Square, the tenant have also actually counterclaim for the deposit and all the previous payment that has been made. And what did the court find? The court said, look, you cannot claim back because there are clauses in the agreement which says that Berjaya can forfeit the security and utility deposit if you terminate the tenancy prematurely. But again, I must emphasize here, it is not an automatic right for you to be entitled, as landlord, to be entitled to forfeit security deposit. It must be spelled out in your agreement. Again, there's difference between security and utility. Usually the treatment is different. But if your agreement actually says that if certain conditions are met or if certain things happen, I'm entitled to forfeit, then you have the right to forfeit. In this case, there was such clause which says that if you terminate prematurely, I can forfeit. And on top of that, you may even entitled to claim for the unexpired term. So again, going back to my first case, your tenancy agreement will make or break your case. So you need to make sure that you have a proper and comprehensive tenancy agreement. Now, what happened if it's the other way? This time the landlord, despite agreeing that I'm going to rent to you 3 years, the landlord wants to terminate. And there's no clause in your agreement which allows either party to terminate. Then the question is, as a tenant, what is your right? Can you actually compel, sue the landlord and compel them to allow me to stay? for the full 3 years? The answer is yes, based on this Privy Council decision of Siu Sun Hua and Yong Dong Hong. It's quite an old decision. But what happened here essentially is the landowner sued the tenant, asking for vacant possession and also seek for double rental because they want back the property, and if you don't give the property, they want to claim rental at the rate double rate. But the tenant then said no, there is an agreement in writing between the tenant and the landlord's dad. And the landlord's dad was the former owner of the property, and the agreement actually says that the tenant is entitled to stay as long as the tenant wants. There's actually such term in the agreement which says that you can stay there for so long as you pay the rent and for however long you want. So then now, when the dad passed away, the land was transferred to the new owner, the son. The son then wants to kick them out, want to kick the tenant out. So the tenant then sued and claimed for specific performance of the agreement, which is essentially a court order to allow the tenant to continue to stay on. So what did the court find? The court find that, yeah, as a tenant, you are allowed specific performance. You should specifically perform the contract. But here, because, like I said, the National Land Code say you need to allow a maximum of 30 years because they're only renting part of the unit, not the full unit. So in this case, the court say you are entitled to rent it for up to a maximum of 30 years. So in this case, the court actually granted specific performance. But of course, usually these days, I've seen a lot of tenancy agreement actually was spelled out as well. What happened if the landlord prematurely terminate? Some may even say that the landlord have to pay the tenant the unexpired term. But these clauses are rare for the very reason because the bargaining power is sort of different. Usually landlord have a better say in terms of what terms need to be in the tenancy agreement. So it's quite rare that you have such a clause in your tenancy agreement. Now, moving on is what happened in the event that the tenant failed to pay rental. This is the second common breach as well. The question is, what can you landlord, you as landlord, what can you do? And the first question that most people will ask, can I evict or can I kick my tenant out by force? And I'm sure most of you know of the common tricks. You change the lock, or you cut off supply of utility, you cut off electricity. Sometimes if you as landlord, you are paying the utility bill, you may choose to deliberately not pay it so that telecom will cut the bill, Shabas will cut the water and all this. These are what you call self-help method. But then the question is, can you actually do that? In Malaysia, is this legal? And unfortunately, the answer is no, you cannot do this because of Section 7 of the Specific Relief Act. As you see, Section 7 of the Specific Relief Act, especially sub 2, it says where a specific immovable property has been let under a tenancy and the tenancy is determined or has come to an end, but the occupier meaning the tenant, continues to remain in occupation of the property or part thereof, the person entitled to the possession of the property. So usually as landlord, you'll be entitled to possession of the property because the tenancy has come to an end. You shall not enforce his right to recover it against the occupier otherwise than by proceedings in court. What does this mean in a simplistic term? Essentially, it means even if you have the right, entitled to the possession of the unit, you cannot kick them out unless you go through court process, unless by proceedings in court. So you must get a court order in order to evict the tenant out, even though it's very clear in your agreement to say, look, come expiry, you must move out. Even so, unfortunately, you have to go to court to get an order. And in fact, this is what happened in this case of Dr. Harjit Singh and Suhaimi bin Samad. So the facts here is the plaintiff is a doctor. He rented a clinic from the defendant. And they were still negotiating the tenancy agreement, but I think he paid some sort of a deposit. What happened was one day, one of the plaintiff's fellow doctors who was also working in the clinic went to the unit, and when he wanted to enter the unit, he found out that the lock has been changed. So ordinarily, the plaintiff then sued the defendant to say, no, this is a breach of Section 7 of the Specific Relief Act. So what did the court say? The court agreed and said that you cannot go and change the lock of the unit because this contravenes Section 7. If you think you're entitled to possession of the unit, go to court. That is the proper way to do it, and you cannot do it by using the self-help method by changing the law and all this. And it said, in fact, the court said in the circumstance, it would be wrong on the part of the defendant to lock up the plaintiff from the clinic and thereby taking the law into his own hand. Such an act amount to tort. Section 7 sub 2 specifically left clearly show the intention of possession of premise may not be obtained except by proceeding in court. So what does this mean? What this means is even if the tenant fall behind on rental, the tenancy is still in effect. You cannot kick them out. You still have to go through the legal means to get vacant possession of it. What you must do is first you must exercise your right to terminate. Because section 7 sub 2 say because you only entitled to vacant possession in the event you terminate, unless you have a clause in your tenancy which says otherwise. So first you must exercise your right to terminate. And after you terminate, then you need to commence court action, get an order to seek for vacant possession. And only then you can evict the tenant. Now, then the question is, okay, if I don't want to kick them out, I still want him to stay there, what are the ways I can just claim for the outstanding rent? So the answer is you have to, go through legal means, of course. You may issue a letter of demand, or you may commence court action. Or alternatively, you can consider what we call a distress action. Distress action is provided under the Distress Act. Essentially, it's an application whereby you apply to court, you invite a bailiff, a court officer to go to the unit, and you actually can seize some of the tenant's goods. You can take some of the item, and you can sell it off in an auction. And whatever that you have sold will be used to settle any outstanding rental. But do take note that the outstanding rental must only be for the past 12 months. So if you want to commence distress action, don't wait for the outstanding rental to be outstanding for more than 12 months. Otherwise, you cannot go to distress action for your 13 and 14 months. Of course, distress acts, there are certain items that cannot be seized. For example, the tenant's clothes, bedding, or any tools or equipment that the tenant used for their business, or anything that is in the tenant's hand when the seizure happened. So these are something that you cannot seize. But what will happen is essentially you go to court, get a writ of distress, get the bailiff to enter the place, and sometimes you may even use reasonable force to enter the place, and then you will seize certain items, and then you come up with an inventory list, and then you actually have to serve on the tenant a notice of seizure saying that, look, I have seized all this item, and I'm going to sell it within X amount of days. And if the tenant wants to redeem all this stuff, he should pay off the rental. You pay off the rental, you can get all these things back. If you don't, then they'll proceed to sell off those items. And whatever amount that you have gotten from the sale, you use to cover your rental, and any balance have to be returned to the tenant. So it's either you go to court or distress action. Now, coming to the next common breach is what happened in the event that, look, tenancy have expired, but for whatever reason, your tenant choose not to vacate the unit, and they still stay there and they still pay you rental. What can you do? What are your rights? As mentioned earlier, of course, you can apply to evict the tenant under Section 7 of the Specific Relief Act. Other than eviction, in fact, you can claim for double rental as well. What do you mean by that? Meaning, but before you even claim for double rental, you need to give what you call notice to quit, meaning to say that your tenancy have expired, and you're telling them, look, you're supposed to move out. I know you are still paying me rental. I don't agree to that. I'm giving you no notice to move out. If you don't move out, I will charge you double rental, meaning if you're paying 4,000 a month, you've given them notice to move out by X period, and if they don't move out, you can actually apply for court order, or you can sue your tenant for double rental, meaning for 8,000 of rental per month. So this is provided for under Section 28 of the Civil Law Act. And in fact, it is also happened in this case of Rohasa Assets in Berhad and Weatherford. So what the court essentially says is you can charge for double rental, but this is only in the situation where the tenant is wrongfully holding over the unit without the landlord's consent. So how do you know that it's without landlord's consent? It's from your notice to quit. Because if you don't give them the notice that say, look, I don't agree with you still staying there, and you just keep quiet and you just keep taking their rental, you cannot suddenly say, oh, actually, for the past few months, you're actually overstaying, and you shouldn't have just paid me 1 month of rental. You should have been paying double rental. You can't say that, because you have to be very clearly made to the tenant that you do not agree with them continuing staying there, which is important, which is why it's important for you to give them this notice to say that, look, I do not agree with you staying there. I know you have been paying me rent, but I still do not agree. Please move out. If not, I'm going to charge you double rental. This is essentially what the decision I've made. So then from all these cases, as you see, there's a lot of repercussion if you terminate prematurely. Therefore, you need to make sure, first of all, you have a clause which allow you to walk away in the event that you decided not to rent. If you cannot agree to these clauses, it's okay. Then perhaps you may want to agree to a shorter tenancy period. If at all you're only committed to 1 year or 6 months, whatever. It's up to you to negotiate. And in the event you need to terminate, you need to make sure that you comply with the notice period. And as landlord, if you do not agree with the tenant occupying the place, make sure you give them notice. Um, of course, now I'm sure many of you may know, and in fact, I think Excel Academy have also given a CPD doc on this point. At the moment, recently, in fact, even since last year, 2022, the Malaysian Parliament have tried to pass what you call a Residential Tenancy Act. And what is the aim of this act? Of course, the aim is, they're saying, is to protect landlord and tenant. I'm not going to go too in depth on this act, because to discuss this, it may be a topic for another day. But I'm just going to highlight some of the initiative that this act is trying to cover. First of all, it tries to provide a template tenancy agreement, which parties should adopt. And the idea of this act is to be a comprehensive law, because previously in Malaysia, your right as a landlord and tenant is all over in different acts. For example, as I mentioned, you have the National Land Code, you have the Distracts Act, you have Contracts Act. Your rights are all over the place. So the idea is they are trying to sort of provide one act for landlord and tenant to look in to see what are your rights. Of course, then the act also tried to establish a tribunal, which is like a mini court to also hear the dispute relating to tenant and landlord. And of course, you have rental control as well, and also you also have anti-discrimination clauses, which says that you cannot say that I only rent to a specific section of people or specific type of people. So you cannot have that. So this act is aimed to address this issue. Of course, it aims to address more than that, but at the moment, it is still at a very prelim stage. It hasn't, Royal Assent has not been passed yet. So whether this act, whether it's going to come into force and when it's going to come into force, yet to tell. So at the moment, it's still important for you to bear in mind a few things that I just mentioned. All right, so that's all we have for today. And here's a bit of background about myself. Thank you all for listening, and look forward to more sessions with Excel. I hope everyone learned a thing or two about tenancy. Like I said, the more you're familiar with what sort of rights, what sort of risks, if you terminate early, what sort of exposure you have, the easier it is and for you to prevent any potential dispute. Always try to have a communication with the landlord, tenant. Always make sure that court should always be the last resort, because it's not cheap to go to court, and it can be a very lengthy process. So if you can prevent going to court, why not? And how do you prevent? You start by having a very, very comprehensive or very properly draft tenancy agreement. Okay, and with that, I would like to thank everyone, and I'll pass it back to Nafa.
All right. Thank you so much, Mr. Chi, for that insightful talk. We'll now move on to the Q&A section, where Mr. Chi will hopefully clarify any questions you have on today's topic. So moving on, we have a question from Ms. Shahrul, Shikin Shahrul. What should we do if the landlord did not address the maintenance issues to the tenant?
Well, there's a few things you can do. One, of course, insist, write a letter to demand that he do it. And if he does that, then unfortunately, maybe you have no choice but to do it yourself, and then to claim the cost to do it from the landlord. Of course, like I say, to go to court to get an order to compel him to do it, it's going to be difficult. But perhaps, another way of looking at it is to write to the landlord and say, look, I've given you opportunity under this agreement. You are supposed to do it. If you're not going to do it, I'm going to get someone else to do it. And whatever cost that I've incurred, I'm going to claim against you. So that's one of the way that you can approach it. But again, like I said, communication is key. If you can communicate, by all means, try to avoid any hostile relationship with your landlord, of course.
All right, thank you, Mr. Chi. Moving on, we have another question from Farid. As a landlord, what should we do when there are further disputes?
Hi, Farid. When you said there are further dispute, I mean, dispute is bound to happen. But the question is, if you have a properly drafted agreement, I think all your rights will be stipulated in the agreement. The question is, what do you want to do? Do you want to kick them out? Do you want to terminate? Whatever decision you make, like I said, you must be very sure that you're entitled to do it under the agreement. Then you're facing a legitimate claim for all the uses. So I guess my short answer is look back at our agreement to see whether there's any specific clauses dealing with these sort of disputes, and in the now, yeah, what's
All right, so we have one more question, but I'm not sure why it's not loading. I have retyped it, so here we go. What happens in the case of early termination of the tenancy agreement?
I see. So again, early termination is not a given right. Not any you can only have early termination if it's expressly provided in the agreement. If you don't have such right and you do it, like the case of Berjaya Times Square, you may be liable to pay for the unexpired term. But when you don't have early termination, usually the tenant will return the keys. You will take back vacant possession, and in the event that they have destroyed or they have modified the units and they have not restored it, as a landlord, on top of just claiming for the unexpired term, you may even sue for any damages you have suffered as a result of the damage done to the unit. And perhaps even in Berjaya Times Square's case, you can even forfeit deposit as well.
Mm, all right, thank you, sir. I believe that was the last question we have for today. We have now actually reached the end of today's episode. Once again, I would like to thank you for your very, very insightful talk just now, and as well as the participants for tuning in today. We hope to see you all in the next round. Thank you. Thank you so much.
Thank you, everyone. Thank you. Thank you, Nafa. Take care. Have a nice day.
You too, sir.
Take care. Bye bye.